of this debate that's sort of been going on as various groups have tried to change the Missouri plan. One of the problems that's been discussed is the level of secrecy and lack of sunshine law applicability to the appellate judicial commission process. And even Justice Stith at one point indicated that she thought there was an opening there for the process to be more open. And in fact, she's posted some of the meetings that previously weren't posted. Separate from HJR 10, is that an issue that the Missouri Bar would be willing to support in terms of changing the appellate judicial commission process, either making it subject to sunshine law or otherwise making it more accessible to the public in terms of the process?
I think the plan is open to the extent that it needs to be open. It's a very careful balance that the plan tries to maintain. You have the needs of the people to have transparency and know what's going on in the judicial selection process. And there is that transparency in that when three panel members are given to the governor, their records, their resume is an open book, and people can go online and take a look at that. But in the early steps, the early part of the process, which is at the end of the day a personnel decision, you have to weigh that transparency against the right of these folks, these candidates, to their privacy. These are people that are employed in law firms or are lawyers around the state, and just like any other employment process, they have a right to their privacy in the early stages of that process. Of course, the candidates themselves can make their candidacies known to folks and can put their records out to the public. But for those who are concerned about maintaining their client base and those who are concerned about maintaining their employment, you have to be very careful in weighing that right and giving a fair shake to their right to privacy versus the equally important right of the people to know. And I think the plan does a good job of striking that balance.
I think that it's a good question, Tony. The interest in an open government, everybody can agree that government needs to be as open as possible. But when you're talking about judicial selection at the beginning stages, where people are simply asked to apply, lawyers are simply asked to apply to become a judge. I've had this conversation with a number of people who have thought about applying and who have applied. None of whom, by the way, have ever been selected. The people who I'm thinking of, who I've had conversations with in the last several weeks.
You don't run with a very good crowd.
Well, I don't. Actually, I do, with respect to some of these people. But nevertheless, the overwhelming sentiment is that the plan is as open as it should be. There is a significant interest, a significant public interest in maintaining some confidentiality in this process, because some lawyers, considering whether to apply, will not apply to become a judge if their name becomes known at the beginning of the process, either because they're afraid they're going to lose clients who are fearful that their lawyer is going to become a judge and will abandon them, fearful of losing their job in a law firm because their law firm decides that they're not loyal enough to the law firm and they need to be let go, fearful of losing income. I've heard of certain circumstances where judges' income was frozen once they applied for a position because the law firm was concerned about whether that person would continue to be a member of the law firm and decided to freeze their income. So there are many negative consequences for a totally open system. And as citizens of the state of Missouri, our goal, what we want, ideally, is a judicial or jurists, judges, who are have the best legal minds the state can produce. If we create a system of rules, a set of rules, that discourages the best legal minds from applying, then we wind